Distinguished Chair, dear colleagues, ladies and gentlemen, we can all agree that the report we are discussing today concerns a very sensitive issue. It is essentially focused on the fight against corruption and efficient management both in the public and private sector. It concerns those employees who are drawing attention to the offences of corruption and other wrongdoings in their working environment, having in mind that the role they play is of key importance. United Nations Convention Against Corruption also states that each state party shall take appropriate measures in accordance with its domestic legal system and within its means to provide effective protection from potential retaliation or intimidation for persons who give testimony concerning offences of corruption. Council of Europe Civil Law Convention on Corruption contains binding provisions which state that each party shall provide in its internal law for appropriate protection against any unjustified sanction for employees who have reasonable grounds to suspect corruption and who report in good faith their suspicion to responsible persons or authorities. Unfortunately, today, many Council of Europe member states have not yet managed to provide appropriate, sufficient, and comprehensive protection for those who are disclosing information to the public at large about the wrongdoings and illegal conduct, and that are of importance for every society which aims to develop and progress, while normative and efficient protection of persons who are reporting the suspicion of corruption is of key importance for the fight against corruption. Many Council of Europe member states have yet to enact a specific law that will regulate protection of those who are exposing corruption, and currently, these issues are regulated by certain legal provisions which refer to labor issues, criminal proceedings, media, and discrimination issues. For this reason, I would particularly like to draw your attention to the fact that on 25 November 2014, the National Assembly of the Republic of Serbia has adopted the law on the protection of whistleblowers, which is in effect since June 6th this year. I believe that the most important is protecting whistleblowers from being put in an unfavorable position due to whistleblowing. Most common actions employers are using to place whistleblowers in an unfavorable position are employment procedure, work outside employment, education, training or professional development, promotion at work, disciplinary measures and penalties, working conditions, termination of employment, salaries and other payments, awards, allocation of duties, and transfer to other posts. Thus, the law on protection of whistleblowers should provide for respect of those human rights guaranteed by the Constitution of the Republic of Serbia, which refer to the freedom and security, freedom of thought and expression, personal data protection, right to work, etc. In every society, especially in transitional ones, the mere threat of corruption justifies the need to adopt a legal framework for the protection of whistleblowers, which will provide for efficient mechanism for disclosure of illegal conduct and wrongdoings. Restoring people's trust in democratic institutions is of high importance. Positive effects of the law in Serbia have created conditions for the strengthening of the rule of law and environment where laws are being respected. At the same time, developments of morals and public denunciation of illegal conduct represents a basis of every healthy system of values. On the other hand, improvement of legal regulations has to be followed with general change of attitude to corruption denouncement. Thank you.